Good morning, Your Honors. May it please the Court, I'm Steve Brannick of Brannick and Humphreys here representing the Peak family. If I may, I'd like to reserve 5 minutes of my time for rebuttal.
Okay.
We have an insurance coverage case here. The Peaks were unlucky enough to build their new home on Davis Island at the time when Chinese drywall was being used. As a result, there was significant damage caused to their home, and they were actually chased out of their home for a couple of years during construction.
Mr. Brannick, I was going to comment at the beginning of this, by the way, that for 35 years I've lived on Davis Island, but I live on the second island, and this is a B Street, so it's got to be someplace around Bahama Circle. I don't think I know where the house is exactly, and I don't think I know the owners, but I live on the island.
Right. Thank you, Your Honor. After a couple of days of trial, we get to the end of trial, and the judge grants a directed verdict against the Peaks, and we think that the judge was wrong to rule as a matter of law and coverage, and that needs to be reversed. The briefs cover a lot of ground, so I wanted to focus today on two main points. First, that there were fact issues that should have prevented a directed verdict, and then secondly, I want to talk about the meaning of the ensuing loss provision in the policy. Now, the easiest way to resolve this case is on the directed verdict ground. There were fact issues here. The first and obvious fact issue is whether or not there was, in fact, a construction defect. The testimony was clear that if you build this house and use Chinese drywall in a drier climate, that you might go hundreds of years without encountering any of the problems you have here. So it raises an interesting question. If you produce a product that works just about everywhere in the world except for a very particular, very hot and humid climate, is that in fact defective? I think that's
the evidence. I have the impression that this drywall was being removed all over the country, not just in the South.
But the testimony in this trial was that in drier climates, it may go hundreds of years without any problems at all. Now, people for prophylactic reasons may be taking the situation in hand, but in terms of the evidence in this trial, that's the evidence that this jury heard.
Let me shift gears on you just a little bit. We changed the law in the middle of this jury trial, and so I guess my question is, when were there jury instructions based on the old law prepared before trial?
That's right.
And when you picked a jury and you did opening statements and put on evidence, was everyone talking about the other theory of causation?
Everybody was proceeding under the assumption that we were going to be under the concurrent cause instead of the efficient proximate cause standard, yes. And so one of the
I guess what concerns me is, rather than the other issues, this is the kind of case that seems to me like maybe it needs a mistrial at that point in time, because you've been trying it in complete good faith under one set of rules, and all of a sudden you're well into trial, and those aren't the right rules anymore.
Well, that's one of the points that we raised in our motion for new trial, is that we should have gone back and had another chance to try this case under the standard that popped up right at the end of the case.
If that's the error, then all the rest of this is filigree for another day.
Well, I mean, we would be delighted if the court reached that result. I think that's a fair thing to do here, is to try this case under the correct standard. But if this court doesn't feel that way, we certainly have to go back because there were fact issues, and it needs to go back because of the ensuing loss provision. And actually, the ensuing loss provision, I think we need a decision on that, because that's going to impact. That could potentially impact this case if the jury were to rule against us on the efficient proximate cause
ensuing loss would probably come in rebuttal, would it not? Once the defense has proven that an excluded peril caused it.
Right.
You can prove exceptions in rebuttal, and then ensuing loss, you didn't get an opportunity to do that.
Yeah, I think the ensuing loss question is a question of law.
I think the concern for us is this. The parties conducted discovery, litigated, prepared the trial, tried the case under concurrent cause. Judge Huey bought that concurrent cause was the standard. And I think the plaintiff made a strategic decision not to call a particular expert because of that. And it appeared to me that you could prove a concurrent cause or contributing cause through Dr. Moon, who did agree that humidity exacerbates it or increases the off-gassing.
In fact, Judge Huey said he was about to grant directed verdict for the Peaks
as
a result of this.
I kind of got that impression, but I more had the impression this was going to the jury. This was going to go to the jury, and it wasn't until the second day when the charge conference is over, Sebo is handed down.
Right.
That's a very tough position for both parties to
Right.
be in.
Oh,
We all have
absolutely.
tried cases, and we can't imagine that happening.
I mean,
So to sit here and second guess and say you should have moved for a mistrial, you should have moved to reopen your case, I'm not so sure that that's the issue, and this is for the defense too, is there was a change. I mean, Judge Hugh, even in his order, says, based on the change of the law, he starts there. But he decides this directed verdict based on evidence that was tried under the guise of concurrent cause.
Right. We absolutely agree. We think that's
And
the
it
basis
seems
for
that
the trial.
efficient proximate cause seems to put a little more burden on the plaintiff now.
No doubt
To
it does.
prove some type of substantial responsible factor.
Yeah, we have to be the primary factor as opposed to a factor. That's a very different test, no question about it.
So is this preserved? Now, plaintiff didn't move to reopen the case. They didn't move for a mistrial. How's this preserved?
The judge decided to discharge the jury. The plaintiffs objected to the judge discharging the jury. The judge overruled that objection, discharged the jury. Had the jury not been discharged, the plaintiff could have made the request to put on additional evidence. So we really didn't get that opportunity because of the discharge of the jury.
Well, I do recall there was a request to allow the jury to decide the case, and then there was a mention of a JNOV. I think the plaintiff did that. Am I right?
Yeah, that's
Please let
correct,
it
Your
go
Honor.
to the jury,
Yeah.
Judge. There's a JOV opportunity after that to resolve this issue.
All right, so that's one basis for a new trial, the fact that the standard changed in the middle and we moved for a new trial on that basis. The second basis for a new trial is that there was evidence in the record, there was a factual question on defect, and more importantly, the one thing that Sebo didn't change was the law that if there are potential different causes in a case and one cause is covered and another cause is not, that's a question for a jury to decide which of the causes caused the problem. The Sebo case says that specifically. If you've got a covered peril and a non-covered peril, that's a question for the jury. And Sebo's consistent with law all across the country on that. We cited many cases from around the country that all say that when you have a question of which cause is the concurrent, is the efficient proximate cause, that's a question for the jury. Now, American Integrity has two responses to that. First, they say that our proposed peril, heat and humidity, is not really a peril. Now, all of us who live in Florida know that heat and humidity can cause very significant damages. It is a peril. It can cause your roof to buckle. It can cause wood to rot. It can cause wood to warp. And on the other end of the scale, extreme cold can cause pipes to burst. There's no question that extremes of temperature, both hot and cold, is a peril.
But
And
the
in fact,
issue, the issue here is if a product is used that is more susceptible to failing because of a condition such as heat and cold, why isn't that a construction defect because the wrong product was chosen or used?
And that certainly would be the argument that they would make to the jury. The argument that you would make in response to that is this happens early on in the process and people don't even know the reaction qualities of this particular drywall as opposed to the drywall that had been used before that. So certainly later on in the process, I think there'd be no argument that a contractor who chooses Chinese drywall in Florida is guilty of defective construction. Early on in the case, I don't think that that's so clear, and at least it's a jury question. So that's one question. But the second question is, let's assume that it is a defect. Now, is it the construction defect that's the primary cause here, or is it the heat and humidity that's the primary cause here? That clearly is a jury question because Sebo tells us that if you have two potential perils, that the jury has to decide.
This is not factually like Sebo. Given that this is essentially a chemical reaction, and it's a chemical reaction that requires both of these things, how is either one deemed to be primary? Aren't they both, I mean, concurrent? Isn't this two things that must both be in the same place? Yeah. And in one of these references I saw, to fire.
Right.
It's a little bit like starting a fire. You got to have all three things to start a fire, and you got to have what you have here to have the chemical reaction to give off the odor. Yeah,
I mean, there's no question about that. And if we were arguing here that oxygen was the efficient proximate cause or carbon was the efficient proximate cause, that's not going to fly. But heat and humidity is something that changes from environment to environment. It's very different in Las Vegas than it is here. It also changes from season to season. It's very much drier in the winter than it is in the summer, and it changes from year to year. Some years are much drier, and some years are much wetter than others. So it's much more like weather in that it's something that changes all the time. Sometimes it can cause a peril, sometimes it can't. I mean, just think of this as a sliding scale.
But we also have to look at not just the facts of this case, but that argument would seem to still apply 5 years after the Chinese drywall was determined to be defective. So the question, I guess, to me becomes not so much the concurrent cause, which is the more efficient cause, but you have a contractor who uses a product that presumably he doesn't know, or the company doesn't know, is going to turn out to be a defective product. So I guess my question becomes, at what point is it enough to let it go to the jury? Did that contractor fail to perform properly versus is it some other cause?
Well, but that certainly goes to the question of whether it's a defect or not. But even if you decide that it's a defect, it's still not the only factor here. The other factor is heat and humidity. And I was about to say, think of this as a sliding scale. You might find there might be evidence, and there wasn't any in this case because nobody knew that we were going to have to figure out which cause was primary. But there might be evidence that some Chinese drywall has just a little bit of sulfur, and it takes a lot of heat and humidity in order for the off-gassing to occur. In that case, a jury may well decide that the heat and humidity is the primary cause. But maybe there's other Chinese drywall that's got lots and lots of sulfur, and it doesn't really matter whether you're in Florida or in Virginia or in Michigan, it's going to off-gas. So the jury might well decide that in that case, the defect is the primary cause. And the point that we're making is that where this case falls along that sliding scale is a classic jury question. The jury had to decide that. That's all we're saying in this
Well,
first part.
No one argues in this case, by the way, but is it established law now that Chinese drywall is a physical loss to property, to invoke property coverage?
Virtually all of the Chinese drywall cases find that there is
Drywall is perfectly fine as drywall. It just happens to stink and let off something that's corrosive, I guess, in plumbing.
But there was the judge granted a directed verdict here on the physical loss, and all of the cases that I've seen have found that it's a direct physical loss. So I don't think that that's an issue, and it wasn't raised in the briefs here. So the only other point I wanted to make on this causation question is we're not talking about something like oxygen or the law of gravity. We're talking about something just like weather that changes all the time. I mean, you could say that we all know that it rains a lot in Florida in the summertime. That doesn't mean that rain is not a peril. Obviously, it is a peril. So you've got kind of a classic chicken and egg thing. Which came first? Which is primary? The humidity.
Using just that example, is rain a peril or is an extraordinarily heavy rain a peril?
Well, rain is a peril unless remember, this is an all-risk policy. And they chose to go into Florida and not exclude this particular peril. They could draft the policy to exclude only extraordinary rain events.
And there are policies that have exclusions along those lines.
But that's their job, not our job. This is an all-risk policy. They have to show you where they excluded it. And they did not.
But either way, under concurrent cause and efficient proximate cause, you have to prove that each cause is independent of one another. And the testimony that I saw from Dr. Moon was these off-gases occur as soon as the sheetrock is made. Humidity, if at all, exacerbates it, just contributes. It doesn't appear to be an independent cause.
But the question is what causes the loss within the policy period, and the only thing that causes the loss within the policy period is the heat and humidity. Again, if you construct that house in Las Vegas, it doesn't off-gas for 300 years. Yeah, maybe a tiny bit, but not to the extent to cause the loss. It's a question of when does the off-gassing, in fact, cause damage, and there's no question that happened here within that policy period.
Well, Dr. Moon's opinion, when he agreed with plaintiff's counsel on cross, was it seemed to be qualified because he said assuming the home was not air conditioned, heat and humidity would have exacerbated and increased the off-gassing by 300 to 400%.
But I think there's no question that even in an air-conditioned home in Florida, you have higher levels of humidity than you would in an air-conditioned home in Las Vegas, just because of the difference in the climates. I want to turn to the ensuing loss provision, because if I don't sell you on the first point and you don't, then I've got to win on ensuing loss. And the problem here is that ensuing loss is not defined in this policy. There are lots of definitions in this policy, but interestingly, one of the most important definitions is not defined. And that's a problem for American Integrity here, because if you look at the cases have very different views of what an ensuing loss means. And essentially, there are two different paradigms in their cases. One set of cases suggests that you look at the nature of the losses. The other set of cases suggests that you have to have two separate perils. So you've got the loss paradigm and the peril paradigm. And let me just use a couple examples to make that a little more concrete. You've got a defective roof, and then as a result of a rainstorm, the defective roof leaks and furniture is damaged in the house. Virtually all of the cases say in that case you've got an ensuing loss. The policy exclusion for construction defect means that the insurance company doesn't have to pay to fix the defect, but because the rain caused consequential damages inside the house, that's covered.
So if you have the house was installed with a defective aluminum component in the electrical system, and that causes the house to burn down, the carrier doesn't pay for the defective electric box, but it
Right.
pays for the rest of the house.
Now,
Is that what this ensuing loss is all about?
That's what one set of cases say, and I think a representative example of that is the Eckstein v. Cincinnati case, has an extensive discussion of that, and that and many other cases say that basically the difference is whether it's a direct loss, whether you're fixing the defect, or whether it's a consequential loss. So they essentially define
The ensuing
ensuing.
loss then, in this case, under that kind of theory, cover everything but the drywall?
Everything but the repair of the drywall, right? All the other damages would be covered. Now, their response to that is to say, well, there are other cases that say you need two causes. And in my first example, the roof example, you've got the defective roof, but then you've got rain. So you've got two potentially different perils. But there's another set of cases that specifically says you don't need two perils. There are cases, just to give you another example, there's a defective wall. And as a result of that construction defect, the wall collapses and lands on a car or some furniture and stuff. There's only one peril in that case.
Comparable to the named insured products exclusion.
Right. And there are a bunch of cases that we cited in the brief, the Vision 1 case out of Washington, the Harbor Communities case, the Lake Charles Harbor case, and the L'Aquila construction case that say that despite the fact that you have one peril, it's still an ensuing loss, because what ensuing loss covers is the consequential losses. So they're not a warrantor of the construction. So we don't go to them to fix the construction, but we go to the insurance company because there were additional losses that nobody contemplated as a result of that defect. So there are a number of cases that say even if it's one peril, as long as there are consequential losses that result, then the ensuing loss provision applies. Now, I'll be the first to admit that they have some cases that go the other way. And there are some cases that they cite, including a couple Chinese drywall cases in Louisiana and Mississippi, that say, no, you have to have a second peril.
Aren't there some Florida cases that hold the ensuing loss exception is not applicable if the ensuing loss is directly related to the original excluded risk? The Tex Pack case?
Pardon me?
The Tex Pack case?
The Florida Supreme Court case is the Swire case. And the Swire case seems to have language that fits our argument. In the Swire case, all of the losses that were claimed related to fixing the design defect in the case. So there weren't any extra losses. And the Florida Supreme Court basically said, since all of the losses you are seeking relate to the design defect, there are no additional losses, and therefore you lose. So what the Supreme Court specifically used the word loss. Now, in that third DCA case that you're talking about, Your Honor, I think they completely misread Swire. They take the other, they adopt the other set of cases, which says that there has to be a separate peril. Now, Swire doesn't say anything about having to have a separate peril, so I think the Tex Pack case completely misreads Swire. But my biggest point is this is a problem for American Integrity because their policy is ambiguous. They drafted this policy and didn't define ensuing loss in the face of two different paradigms of interpretations out there. One that would cover it if it's a consequential loss, and one that requires a separate and independent peril. Why don't they have to be specific enough in their policy to choose one of those two paradigms?
Frank, we're already up to about 19 minutes, so let's get if we're gonna save some rebuttal time, I probably need to sit you down here shortly.
So I'll close with that. There are two paradigms. They could have chosen which paradigm applies. They didn't. Their policy is ambiguous. So you don't have to choose whether I'm right or the other cases are right. All you have to do is say they should have chosen which of those ensuing loss theories their policy covers. They didn't. That's their problem. So they lose.
I'll give you 3 minutes for rebuttal and make sure you have the extra 3 minutes as well. So.
May it please the court. I'm Andy Rock for Appellee American Integrity. Good morning to y'all. We ask that you affirm the judgment that was entered, and frankly, the reasons for doing so are all set forth in the trial court's order. The trial court found in every respect that American Integrity's policy did not respond to this particular loss because Chinese drywall is a defective product.
Let me ask you this question.
Yes, sir.
Before Sebo, did the plaintiff have to put on expert evidence to prove any concurring cause?
They did, and this is why, Your Honor. The trial court judge was correct in citing that the law changed. There was no law in the Second District before Sebo on this particular point. As the Sebo court acknowledged, there was a paucity, if you will, of law on first party coverage issues relative to concurrent causation or efficient proximate causation, but nevertheless, there was law. And as the court pointed out in Sebo, in the First District, there was Phelps, which made mention of efficient proximate causation, and there was also Wallach, of course, in the third. So this was not a resolved issue. This was something that was to be argued at the charge conference and fought.
Well, help me out with my impression.
Yes, sir.
We've all tried a lot of cases, and this has never happened to us. And it appears that in the charge conference, 3/4 of the way through the charge conference, defense counsel, I don't know if you may have tried it, I guess.
Yes, sir.
You had adopted the concurrent cause. You had been traveling under the concurrent cause. You were agreeing to jury instructions under the current concurrent cause. I looked at plaintiff's opening that refers to the concurrent cause, so the jury was basically educated on concurrent cause. And then right at the end of the charge conference, where this judge, who I thought was going to allow it to go to the jury, and for all intents and purposes, gets a new case that he candidly expresses in his order that is a change in the law. And apparently for you, it is a white stallion for you to jump off your black horse and get on the white stallion and ride. And I don't blame you for doing that. But help us with this problem that we have with all of the evidence was tailored for the concurrent cause. Plaintiff made a strategic decision not to call an expert. You would have to agree that the efficient proximate cause standard found in Sebo requires the plaintiff to do a little bit more than to prove just a loss during the policy period. They've got to prove that that loss was the substantial cause. That wasn't done here, but yet the trial judge takes that new case and applies it to evidence that wasn't even tried under that standard.
It was a unique experience, Judge, at about 11 the night before the jury was to get the case, to come across this new case, which I'm happy to say my office spotted. In any event, there it was. It essentially eradicated the plaintiff's argument. Now, that wasn't our fundamental argument, Judge. Our argument was simply that they had not established any covered peril that would respond to this particular situation. So, in that way of looking at things, they didn't have to change a thing, Judge. In fact, they chose to rely on Dr. Moon because Dr. Moon said what they presumably would have had their experts say, which was that...
You have the burden. I don't know how this case was tried, actually. Did you, since this is an exclusion, did you concede that it was your burden, and were you essentially the plaintiff in this case?
Yeah, essentially, but, Your Honor, it was a shifting burden of proof consistent with Hudson. So the directed verdict for the plaintiff indicating that they had established a loss during the policy period then had the effect of shifting the burden over to us. So we didn't have it from the get-go, but we did after that ruling.
This is really like changing the pleadings. I mean, there's a change in the law, but the theory of your exclusion becomes dramatically different, I guess, because of this change in the middle of the trial.
Oh, yes and no. They could have essentially done, as I've seen before, they could have opted not to call an expert and instead attack the credibility of the defense expert. But they fundamentally didn't need to do that because the defense expert
You
acknowledged.
amend your pleadings to have the new efficient cause theory as compared to the concurrent cause theory.
We didn't plead either. In fact, it really relates more to exactly what the fundamental decision is going to be made by the jury. That is at the charge conference with the jury instructions and so forth. No.
Why is it as a matter of law that this is excluded under the efficient cause theory?
Two answers to that, Judge. First, under primary efficient causation, as the Sebo court acknowledged, generally determination of the primary cause is a matter for the jury. And in fact, in the decision, the word usually is used. So even the Sebo court acknowledged that it's not always.
And it's your burden to prove that that the exclusion is the primary efficient cause.
Yes, sir, it is. And under this set of circumstances, that's exactly what happened.
Yeah, but once you do that, the plaintiff has the right and the opportunity to rebut that with their version of the efficient proximate cause, correct?
If they choose to do it that way, yes, sir, or they could take it off.
That's the new law that was applied to this case where the plaintiff under concurrent cause, there's no duty or obligation for the plaintiff to put on expert evidence to prove some proximate cause. All they have to prove is a concurrent cause.
If there is, in fact, a covered concurrent cause, and I don't want to lose sight of our fundamental position here before the panel, there is no covered cause of loss that's been cited. This whole notion about heat and humidity somehow being covered, that's exactly the evil that the court was attempting to avoid by adopting the efficient proximate causation standard. In fact, the Sebo court acknowledged and referenced Chadwick, the California case, in which it said, if every possible characterization of an event were counted as an additional peril, the exclusions would be meaningless. And that's exactly right. There isn't an exclusion for heat or humidity or gravity or air or atmosphere or any of the other things that played a part in the chemical reaction that made that Chinese drywall defective. There isn't coverage under any view, and that gets back to the panel's question about the directed verdict.
I'll make it plywood rather than drywall, and it had a fire retardant of some sort put on it that strangely enough, when it's up in the attic and it gets heat in the attic, it gives off a gas that is actually inflammable, and the house burns down because of the gas emitted from the plywood. Is the fire in the house no longer a covered risk because of this?
Oh, no, that gets into the ensuing loss argument, Your Honor. And under those circumstances, the fire that is a separate, independent, distinct peril, if you will, that is covered by the policy.
So why isn't this chemical reaction and ensuing, it's not just sulfur sitting in the drywall that does this, it's the chemical reaction that gets out into the environment. That's sort of what the fire does.
Well, two things, Judge. In the fire example, fire is a covered peril. In this instance, the two things that were cited by plaintiffs as being the ensuing loss, specifically the corrosion and the odor, both of those things are excluded. They are pollutants. There is a specific corrosion exclusion, and the ensuing loss provision that's in this policy does speak to that. It specifically says that if an ensuing loss not otherwise excluded occurs, those results, if you will, if they're independent, and I submit that they're not, but if they are, they're still excluded, unlike the fire in your example. Now, this whole matter...
This is an all-risk policy. I haven't carefully read all of this policy, but this is not one of these new hybrid policies. This is a true all-risk policy with exclusions, apparently.
As both attorneys acknowledged during trial, it is a hybrid, but for purposes of our discussion, it's all risk.
It's an all-risk
The
policy.
provisions that we've been discussing are all risk.
It doesn't have to have fire as a named peril in this situation.
No, it doesn't, Your Honor. But it is interesting to take a look at the specific construction of the policy, because after the all-risk granted coverage, there are certain perils, if you will, that are listed as non-covered perils. And that's what 3 out of the 4 independent exclusions fall into. The only one that falls into the actual section of the policy that references exclusions would be the defective construction and use of defective construction materials. So under no reasonable view of this evidence or any inference that could be gained from that, could there be coverage under this policy.
Is there evidence in this record that would have allowed a jury to decide that this type of drywall would not have been a problem in North Dakota or Minnesota, but it is a problem here?
No, in fact, that is the subject of the cross-examination that the opposing attorney attempted to put on Dr. Moon. And Dr. Moon said, look, this reaction is going on from the moment that Chinese drywall is created. It happened from the time it was created, manufactured in China. It went on during the trip across the sea.
I would assume at least, sort of like a fire, that you can have oxidation that doesn't really result in much damage, but when it turns into a full-blown fire, you're in big trouble. Isn't one of this, is there a possibility that the chemical reaction could occur slowly enough in some environments that it doesn't result in the kinds of odors and corrosion that this apparently causes in Florida?
There was no evidence to that effect. In fact, Judge Moon said the reaction would be inevitable. There's no element of fortuity in the problems that this Chinese drywall had. It may be slower, it may take more time for it to happen, but it's going to happen. And
Well,
all of the
it may happen and release in a slow enough amount that no damage will occur.
that it wouldn't be discernible for a period of time, Your Honor. And I
Or
think
it may never be discernible because it releases so slowly over whatever extended period of time that no damage ensues.
apparently a lot of people aren't willing to take that risk because they're getting the Chinese drywall out of their homes regardless of where they live.
Well, let me ask you one question, and you've sort of alluded to this. Your bottom line position is that whether the new case applies or the old law applies, the exclusionary language of pollutants and exclusionary language of odors and corrosion, that those exclusions control no matter what. Am I understanding that's your bottom line position?
Yes, sir, that's it. And moreover, these so-called covered causes of humidity and heat, those are abundant. They are a product of living on the planet Earth, and it's not abnormal humidity that causes this creation, this chemical reaction or interaction. It's the presence of any water.
What my question's really going to, you're saying even if your client concedes that they're correct, that heat and humidity are significant factors that have to be taken into account, your position is still the exclusionary language applies?
Yes, sir. Yes, sir. And it's very clear exclusionary language, as the trial court pointed out. There are 4 distinct areas. There are exclusions for pollutants, and it's very clear under the policy that that includes gaseous materials, vapors, and fumes, specific words utilized in the policy. There is an exclusion for corrosion, which has been upheld in a Chinese drywall situation by a trial court in Virginia. There is an exclusion for latent defect, and the only testimony in this case was by Dr. Moon relative to causation, and he characterized it as a nail in a cake. This is drywall that looks like other drywall, but because it contains elemental sulfur, as soon as it's created, it off-gasses, it creates the bad odor and the corrosive properties that exist.
Did the trial court actually rule in the directed verdict on some of these other exclusions, or is it just this primary efficient cause issue that...
Interestingly enough, Your Honor, I haven't been the recipient of too many over-the-park home runs, but this was one because the judge did take a look at every single exclusion that I've just mentioned to the court, including defective construction and defective building materials, and in his order that was entered, addressed each one and found each one independently to apply to this matter. He also addressed the ensuing loss argument that was made and said, this is not a covered ensuing loss for 2 reasons. One, it's not a covered loss because the things that happen, specifically the odor and the corrosion, those are specifically excluded. And then he also said that they are not independent losses. They're not different. They're inclusive of the very chemical reaction that makes that Chinese drywall defective in the first place. So this is not anything like the example given by Your Honor with the defective aluminum giving rise to a fire. Fundamentally, that's the situation, Your Honor. I would love to say that I had some part in a developing body of law with Sebo and so forth, but I don't think we even necessarily need to go there. The fact that this policy excludes each of the posited causes of this loss, specifically, regardless of any theories as to heat or humidity, results in a finding of no coverage that supports a direct verdict. Okay. Unless there are any questions, I'll sit down. Thank you.
Thank you. Brannick, if, I don't know, there's a ship comes into Tampa Bay and it gives off a gas identical to what this drywall gives off, and the gas fills this house on Davis Island. Isn't that excluded by the pollution exclusion?
Yes, it would be.
What,
Because it's caused by, but I think, remember, this is not an exclusion for pollution losses.
The
This is
damage
not,
here is not done by drywall, it's done by the gas created by the sulfur in the drywall, right?
if we're talking about ensuing losses, we've already decided that essentially the construction defect is the efficient proximate cause. If you look at the exclusion, it is not an exclusion for pollution losses or an exclusion for corrosion losses. It is an exclusion for losses caused by pollution, losses caused by corrosion. And the cases say that there is a difference between so our argument in this case is that the pollution and the corrosion is not the cause of the loss, it is the loss. The cause of the loss, again, if you buy their argument, is the construction defect. That's the cause of the loss. And the loss is the corrosion, the loss is the pollution. There's a really good case that illustrates that. That's the Eckstein v. Cincinnati case. It's a federal district court decision out of Kentucky. And in that case, you had a construction defect. It allowed water intrusion, and it caused mold and all sorts of toxic gases. There was an exclusion, very much like this case, for construction defect and an exclusion for mold. What the court said was the construction defect was the cause. And then it moved over, as I suggest that we do, into the ensuing loss provision, and then said the mold in that case was not the cause of the loss, the mold was the loss, and said you have to distinguish between a situation where you've got a construction defect that causes mold becomes the loss at that point in time and then is covered, as opposed to a situation where just mold arises in the environment and causes loss. Then you've got an exclusion, and there are several cases that we cited in our briefs that make the distinction between something being the loss itself and actually causing the loss. And again, I will say that just as in my other argument on ensuing losses, there are cases that go the other way. My point again is that creates an ambiguity here. They could have written this ensuing loss policy. They could have written their cover of perils in such a way to make it absolutely clear which legal direction that they were going in. They didn't. They chose to draft this policy very generically and in a way that allowed them to be nimble now and make the arguments they're making for this court. They should have drafted this policy much more specifically to make it clear that we're not talking about just losses caused by pollution, caused by corrosion, but the losses when corrosion and pollution is a loss itself. They could have made that clear. They could have made it clear whether they're talking about needing an additional peril to be an ensuing loss. They didn't do that. The policy's ambiguous, so even if you buy their legal arguments, they've still got that ambiguity problem. So what we suggest is that you reverse, remand for a new trial, but we would also like you to reach the ensuing loss question, because obviously if the trial doesn't go the way we would like it to go the next time around, we need to know the answer to those questions.
Thank you.
Thank you.
Next case is Kinsner versus City of Sanibel.